You're listening to Clause 8, the voice of IP. Today's guest, Nick Matich.
Some frequent defendants basically got used to having multiple opportunities to challenge a patent, and they got upset when that got curtailed even a little bit. That's why it was controversial, but fundamentally I think it was sound policy. In every other area of law, two litigants fighting about something, they were only going to spend the judicial resources to resolve that dispute once, except the way the AIA has been implemented in the patent space will give multiple opportunities to resolve the same issue, and that's just a waste of society's resources and unstable and destabilizing to the patent system.
Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for the Patent 300 for patent preparation and prosecution. After you're done listening to this episode, don't forget to share it with others, and please leave a 5-star rating wherever you're listening now. And now here's your host, Eli Mazur.
Today we're lucky to be joined by Nick Matich. He served as Deputy General Counsel at the Office of Management and Budget and General Counsel at the USPTO, before joining McCool Smith as principal to focus on patent litigation. When the USPTO released its recent, it's a mouthful, but the advance notice of proposed rulemaking for changes at the post-grant proceedings, I immediately thought of you because you're the only patent litigation attorney that I know that not only served at the USPTO, but served at the OMB, which obviously is involved in approving rules, and the White House, which theoretically has influence on that process. So you've seen it from all sides, from all different levels of administration. So thank you so much for joining Clause 8.
So glad to be here. Thanks so much for having me.
You had a very interesting journey to patent law. You served in the Navy, went to law school, clerked on the Fifth Circuit, I believe, and then you joined shortly after that a legendary firm, Bancroft PLC, which was led at the time, I believe, by Viet Dean, who's now the chief legal officer at Fox News, and the legendary Paul Clement. Most consider him the top Supreme Court advocate in the country. What did you learn from working at the firm? Did you have a chance to work with either of these attorneys directly?
Oh, yeah. No, I worked with Paul and Viet very closely. They were both fantastic bosses, very different practices from each other and from what I do now. But I learned a ton from both of them. I was, honored and pleased to get to work with them. And, like for Viet, he's got when he was in private practice, he had a very unusual docket of some regulatory stuff, some litigation stuff, some criminal stuff. That was, other than my clerkship, that was actually probably my only exposure to working on criminal cases. And they weren't even U.S. criminal cases.
Yeah. And what did you, obviously, I'm guessing the reason he became the chief legal officer at Fox News is because his specialty is probably solving very hard, unique problems.
Yeah, I'd say that's definitely Viet's specialty. And that's probably the link between Viet and Paul is that's what both of their practices are basically about. But yeah, Viet sees not just the legal aspects, but the business aspects of a problem, thinks about sort of the practicalities of it. He had some relationships with Fox before he became the GC. So I think it wasn't a total surprise that he ended up there.
So is there anything, I guess, that you learned that you take to your patent practice now in terms of another patent litigation? You kind of know how it's going to work. You're going to have a Markman hearing and blah, blah, blah. Is there anything, I guess, you learned about thinking unique problems that you take to your practice today?
Oh, yeah, absolutely. I mean, because patents are fundamentally business tools. And anytime, you have IP or an IP situation, you're what the business really wants or what the people involved really want is a business solution. And so, it's great to think about the litigation as you file your complaint and then you serve discovery and you have a Markman hearing and eventually get to trial and so on and so on. But basically, you're trying to solve a business problem and reach a business deal. And thinking about understanding about what markets is a company in, what other kinds of IP we have, what's actually motivating them, how can we get a license deal done, just thinking outside the box and how to structure licenses to settle a case or anything like that. Those are all that's what I enjoy most about my practice.
No, that's interesting because I've had previous guests talk about how sometimes patent litigation attorneys, all they can think about is, how do I win that patent litigation or get to trial and win that, instead of, like you said, getting to maybe a win-win resolution, if that is possible.
Yeah. I mean, so like, and my practice isn't strictly just patent litigation, although we do lots of that. But for example, I've got a client who has a pretty significant SEP portfolio, and we're helping them license it. And so there's a lot of thoughts there of who's the right person at the companies to reach out to that we want to license the patents to. How do we get them to pay attention to us and, take a meeting? And then ultimately, how do we structure these licenses once we get to that point?
So Paul Clement, he's known as a top conservative legal thinker. In the patent policy field, he's known for writing a white paper for a lobbying group, arguing that conservatives should not think of patents as property rights and should support recent Supreme Court decisions limiting patent rights. My question is, did you have any chance to discuss patent issues with him while you were at Bancroft? What do you think about that paper in terms of, I know you're involved in kind of the patent policy advocacy field. What do you think about a paper like that existing out there?
So I never talked to Paul directly about that paper. In fact, I don't think I was made aware of that paper until after I left Bancroft. But I don't know if that actually reflects Paul's personal views or not. I never actually had a conversation with him about what he thinks about patents or patent law. We had patent cases at Bancroft and represented both patent owners and defendants.
And did you work on those patent cases while you were there?
I did. And so, like, part of the reason they brought me on is they wanted someone with an interest in IP, because there was another guy who was leaving, and I was brought in partly to replace him on sort of the IP side of their docket.
Do you remember when you first learned about patents? Do you remember what you thought about them?
Yeah, I mean, I knew of what patents were even when I was a little kid. The story of how I got into patent litigation, it was like 100% by accident. I'd never really thought about doing patent litigation, and I was doing my 2L like law firm interviews when I was in law school, and I was it seemed attractive to me to go to a firm where I could work in a suburban office. And Cooley had one of those, and I interviewed with Cooley, and whoever was interviewing me said, well, we're hiring for people for our patent practice. Are you interested in patent law? And I developed an immediate and intense interest in patent law. I'd never taken a patent class, but I did the next semester to prepare for like my being a summer associate. And then I found out I really liked it, and then did some patent work when I was at Williams and Connolly, and then at Bancroft, and then ultimately went into the government.
When you joined the government, you eventually worked as Deputy General Counsel at OMB. What did you learn about the rulemaking process while you were there? Oh,
the OMB job was a fantastic job. I mean, one, I enjoyed both the bosses I had there, but then two, you get to see the regulatory process from the inside and learn about how it all happens, not just at the agency level, but all the way up. Because what a lot of people don't appreciate is that all of the rules end up getting reviewed by OMB, who's involved, in the process, especially for particularly important or potentially controversial rules. So when I was there, I was, reviewing rules primarily from a legal perspective, but OMB also has policy input as well.
Tell us a little bit of what happens. So some agencies submit some rules to the OMB, or at least that's what you hear in the news. What happens then? Does it just sit there until somebody says, all right, maybe you should take a look at this, or is there a more structured process for how that happens?
Well, there's a structured process, but like anything else in the government where there's a docket, things can sit for a while if no one takes it up. But often for rules that an agency cares about, they'll be talking to OMB, and they'll be, at the secretary level, at the deputy secretary or assistant secretary or undersecretary level, you'll be having conversations about the rules that are coming out. Now, actually, the vast majority of the rules that go through OMB or agencies, just like the vast majority of the bills that get passed through Congress, no one really cares about. They're not controversial. They're cleaning something up, fixing something small. And OMB doesn't have a ton of involvement in those except to look at them and say, we're not interested in reviewing, because OMB doesn't have the bandwidth to look at everything.
Most rules, I actually didn't realize it. So most rules that end up as rules, proposed rules, the OMB just rubber stamps them
I wouldn't say rubber stamp. I would say they don't even look at them at all. Yeah. So
okay.
in the executive order that governs the OMB review process, there's actually a threshold of $100 million impact on the economy, which I think President Biden actually may have just tweaked, or something that has some other important policy impact. So, rules on social policy that are controversial might get an OMB review, even if, economically they're not terribly important.
So I'm guessing when an agency submits a proposed rule to OMB, they kind of provide that information. And obviously they work with administration, so they're going to be kind of honest and transparent. And do they flag this might be controversial at that point? You might want to get input from other parts of the government, or how does?
Maybe, maybe not. It depends upon if the agency thinks they're going to have a conflict with OMB. Because the one thing I learned in government is that even though we have this, theoretically unitary executive where the president's in charge, there's lots of people underneath the president that will have lots of different views on things, and both substantively or sort of, practically what's the best way to achieve our shared goal. And so the OMB and the agency may not see eye to eye. OMB and the White House or different components within the White House may not see eye to eye on how to address, some issue within a rule.
You hear about a proposed rule, being submitted to OMB. Is at that point people from other parts of the government, the White House, are also reaching out to OMB to say, we don't agree with this rule? Or
no, I mean, so often, but usually before the rule gets to the formal OMB process, there's probably been some discussion, at least at a conceptual level, of, hey, this as an agency is what we want to do. Is our folks in the White House on board? How are they going to react? Are there tweaks we could make, or things we should omit, whatever?
And who does the agency have the discussion with? People in the White House or with the OMB?
Both, because the OMB is part of the executive office of the president, and so it's actually physically housed in the executive office of the president, the old executive office building, which is where 90% of the White House staffers are. Their OMB is based, on the second floor, and the White House staff is on, the first, second, third, and all the way up floors.
What advice would you give to somebody who's outside the government and they don't like a random agency what they're proposing, and the agency is not listening to their views? What is an effective way to influence the process?
Well, so the executive order that governs the process instructs OMB to take meetings with basically anyone who wants them on rules that OMB has under consideration. So you can actually get meetings with OMB staff. How effective are those going to be in steering the process? It probably depends a lot on what the rule is and what OMB's views are and what the agency's views are. I think in general, you're probably better off communicating with the agency itself, because they're the ones who write the rule in the first instance. And of course, that's what the comment process is for. And then also, if your comments aren't listened to, you might be able to sue.
We'll discuss probably more of that in the PAN space in a little bit. But I want to talk about your journey to the USPTO, where you became acting general counsel. I mean, how did you end up working there?
Also totally by accident. So I was at a party celebrating a friend who had gotten appointed to be an Article III judge, and Macon Delrahim, who was the head of the antitrust division at DOJ.
A previous Clause 8 guest as well.
Yeah. Also a guy with strong views on IP. Yeah. So I knew Macon from his time, our mutual time at the White House, and we were just chatting at this party, and I told him I was actually thinking of going back to private practice. And he said, well, I know you like IP, and I know this guy that runs an agency out in Virginia that's looking to hire someone. And he introduced me to Andrei, and then Andrei hired me.
And before you joined the USPTO, did you have any sense what the administration wanted to do with regards to patent policy? Was there kind of like a view? You said like Macon had strong views about IP, but did others as well? Or
yeah, well, it's IP, like a lot of issues, is one thing where not everyone in the administration necessarily all had the same views. But I generally knew what where Macon was coming from, and I generally knew where Andrei was coming from, and I knew that my views were, more or less simpatico with theirs.
Did anything surprise you when you joined the USPTO? Obviously, you've interacted with a lot of other agencies by that point, but that being in the USPTO kind of in your revelations?
No. I'll say one thing. When I first got there, someone proposed something, I don't even remember what it was, and suggested to me that it might be controversial. And of course, I'd come from OMB, where we were reviewing all the rules government-wide, and I thought, well, geez, this is probably not even the most controversial thing I've looked at in the last week.
So maybe a little more paranoid.
Yeah. No, I think the thing is that one of the things I like about IP, I mean, there are definitely controversies within, the IP practitioners and folks in IP-intensive industries, but it's a little more bipartisan than other places. Like you've seen in the Prevail Act that just got introduced, it's got as many Democrat or maybe more Democrat sponsors than Republicans, and IP doesn't cleanly cut along conservative, liberal, Republican, Democrat divides.
So you mentioned the unitary theory of executive. In the patent world, if you're just a patent attorney who's not that interested in politics, you tend to think as the USPTO director. He's in charge of all patent policy, and anything good that happens, it's his fault. Anything bad that happens, it's his or her fault. From your sense, you mentioned you were at White House, then the OMB, and then the USPTO. And I'm sure each administration is different, but from your sense, who really controls patent policy within an administration? Or
I think it probably depends. It probably varies a lot administration to administration, because IP is one of those things that you may have someone care deeply about it, like Macon, who's not in a formally IP-related role. I mean, like there's I guess some overlap between antitrust and IP, or maybe the question is the dispute is really whether or not there's an overlap between antitrust and IP. And so you can have different folks who have different takes on it. The National Economic Council could easily have strong views and end up weighing in a given administration. I think, for example, I've heard anyway that like Tim Wu in the current administration when he was there was, had influence over IP policy. The FTC director has views on IP, and all of them can end up shaping where an administration goes on IP policy.
Big policy initiatives in the administration when you were there was changing the administration's policy on standard essential patents. And obviously there was a lot of talks about different agencies weighing in on all that. And it seemed like were you at the USPTO at that point? But
I was, okay. Yeah.
Because it seemed like, the USPTO the USPTO wasn't really ready to jump on board about making Del Rahim's proposal at that point. Is there any insight they can give us of what was like kind of holding the USPTO back?
I don't know that there was anything holding the USPTO back. I wasn't. I was there at the end when we actually got the statement issued in 2019, and I helped get it over the finish line.
Yeah.
But from everything I saw on that issue, the NIST, USPTO, and DOJ were all, rowing in the same direction and had similar views. There were, potentially points of emphasis that were different or things that were, unique to antitrust that PTO didn't necessarily have a stake in, but on the whole, there was unanimity among NIST, DOJ, and PTO.
We talked about what happens to proposed rules once they reach OMB. Curious to hear your perspective about, at least your time at the USPTO. How did it go about? There's a million things that the USPTO can do, but talk a little bit about the process internally, about how they thought about what changes are necessary and how they should go about implementing those changes in terms of how the USPTO operates.
As far as rulemaking goes?
Yeah. Or I guess that's part of my question. Sometimes it doesn't go through a rulemaking, right?
Yeah. I don't know that it's terribly different at PTO than it is at other agencies. I mean, every agency has their own quirks, but every agencies often like not going through rulemaking because, well, it's a lot less work.
Yeah.
And you can you can implement whatever it is you're going to implement, pretty quickly. As you write up whatever the document is, the guidance document, and issue it. Now there are problems with that. And there are downsides to that, but most agencies like to do that if they can. I'm not sure that's always best practice. And often within an agency, there will be different views on, whether or not a particular policy change is appropriate for not going through rulemaking or needs to be done through rulemaking. And every agency has to kind of sort that out on a case-by-case basis, because you can do guidance documents, you can do precedential decisions, you can do rulemaking. There's lots of different forms that agency policies can take.
So is that part of the discussion? Let's say whatever the policy goal is that you want to accomplish by making these changes, is that part of a discussion that should we go through the rulemaking process or do something else?
Oh, absolutely. Like it's always part of the conversation. If you want to, affect some change, whatever it is, one of the first things you always ask is, what's the right vehicle to accomplish the change? Do we need to go through a rulemaking? And so you need to see, is there a rule on point already? If there is, are we simply interpreting the rule, or are we, radically changing it? What's the statutory authority for what we're going to do? Is there an adjudicatory process that we could go through that would implement the same thing? And,
And sorry, by the last thing, is that kind of like when a PTAB issues a decision?
Yeah, so at the USPTO, it would be the PTAB, but other agencies have the similar kind of process. There's FERC, NLRB, have adjudicatory proceedings. There's lots of agencies that will use adjudicatory proceedings to implement policy. And PTO's obviously done that we had the POP panels under Director Iancu, post Arthrex. Now Director Vidal is, she's able to just unilaterally make decisions.
Another dynamic, I'm sure that's true in any agency. You, like you said, you joined the USPTO and then you're a general counsel. There's probably people that have been there for decades, and I'm sure some of them have very strong personal views about what the USPTO should do. Is that a difficult part of a director's role in terms of trying to get everybody internally on board, or do you have to make a case internally? Or
well, I mean, anytime you're leading an organization, you want to bring your people along with you, and anytime you have a large organization, the PTO or any government agency is no different. The people involved are going to have strong views on what you're doing, and not surprisingly, lots of people at the PTO that have been there for decades and are, great civil servants have their own views on all the policy issues. And they're not all the same. There are there are folks who think the AIA was great. There are folks that think it needs to be changed. There are folks that think it needs to be changed significantly. There's different views on international issues. So yeah, as a director, a challenge you always have is getting people to help you, take the agency in a direction you think it needs to go in.
You mentioned that obviously there are easier alternatives to the rulemaking process, but from what I understand, the benefit of the rulemaking process is that it's harder to undo those changes.
That is one benefit from the point of view of the agency that's doing it. Obviously, if you don't like the rule, that's a bug, not a feature.
Yeah.
That is one of the benefits, and I think in the IP space in particular, it's good because. Maybe not even in particular, but in the IP space, it's good because we're trying to establish a property system, and unstable property systems don't function as property systems.
Some of the more controversial changes that happened while you were at this USPTO had to do with the PTAB, post-grant proceedings at the USPTO. There was a lot of complaints that those weren't going through the rulemaking process. Did you have a concern that those would be undone by the next administration, or?
I think everyone recognizes that when an agency implements proceeds through adjudication, that it's relatively easy to undo. The NLRB is actually pretty famous for pretty drastic swings in their policy through the adjudicatory process when administrations change. And so you'll have very pro-labor set of board members, and you'll have a very pro-management set of board members. And so if you do
but I guess specifically, was that a worry?
I actually wasn't there when Andrei implemented the POP process. I actually think my first day might have been the first actual POP hearing where he was there. I could be wrong about that, but I also don't know that I'm willing to say exactly what I said to him.
All right, we'll save it when you retire. All right. You mentioned about you said the best, if you want to actually influence what rules or what changes an agency makes, the best place to start is the agency. It's not that difficult to meet the USPTO director, for example, but sometimes they listen to you, but they might not respond, or they don't make the changes that you want. I mean, what other alternatives would you recommend to that in terms of trying to change what they do?
So I think there's as sort of a concerned citizen or concerned business in the U.S. There's a lot of things you can do. Members of Congress actually have a huge amount of influence over the regulatory process, albeit indirect. They obviously don't have any direct input, but when agency heads get letters from the committee that oversees them on Congress, expressing a viewpoint on something, that matters a lot. So, if you can get your member of Congress to, if your member of Congress shares your views and is willing to express that to the agency, then it matters, and it matters a lot if they're on the relevant committee. So that is. That's an important way. Obviously, commenting, I wouldn't underestimate that. I mean, both because agencies do read the comments. Often they know what they want to do. But, there are procedural and substantive challenges you can make to rules. And that's what administrative laws, that's what administrative lawyers in D.C. get paid to do.
You write a lot about patent policy issues. Do you think an agency pays a lot of attention to that kind of stuff, where what people in the field are saying, their new proposals are bad, or they kind of expect the blowback?
I think that actually varies a lot agency to agency. Yeah. So some agencies, the policies, there's a strong left-right, Republican-Democrat divide on what the policies are. And I don't think that I don't think that the Biden administration EPA officials probably care very much what the Trump administration EPA officials have to say on whatever they're doing. And just as the Trump administration EPA officials probably didn't give much thought to what the Obama administration officials thought. IP is a little bit different because it is a smaller community, and there's not as much of that divide there. So I think people do care more. And I know that when I was at PTO, Director Iancu cared deeply what sort of the general community thought, because what we want is ultimately a balanced IP system. We don't want something where patent rights patent rights could be there could be problems with a system that provided patent rights that were too strong. But there are also problems that when you have a patent system that's too weak, and ultimately what you want is a balanced system. You want defendants to be able to challenge patents, but you don't want those challenges to be interminable and make it impossible for patent owners to actually enforce their rights.
It's a good transition to my next question. Some of the major changes that Iancu made at the USPTO had to do with the PTAB and post-grant proceedings. I mean, what did he see as the main problem with the PTAB when he became director, and what was he trying to accomplish with the changes that he made?
I think the concern with the PTAB is that he had, and that I think I share, is situations where patent challengers get multiple bites at the apple. And that can take a variety of forms. It can happen when you get multiple bites, one in the PTAB, one at district court, one through a patent challenge proxy entity like Unified or Escaladen, and also in district court and also at the PTAB, can take the form of serial petitions, parallel petitions. That's like it all revolves around the issue of quiet title and whether or not you're going to get multiple bites at the apple.
Well, let me know if you agree. I think the most controversial change had to do with the FinTIF factors that he implemented. I think it was a PTAB decision, actually, right? The one in POP panel, where after that, the judges at the PTAB take into account those kind of factors to determine whether they should deny an IPR filing. Do you agree? And I guess, why do you think that was so controversial in terms of, if there's a district court litigation going on and you file a PTAB proceeding, but it doesn't happen, okay, so there's already a district court litigation going on.
That's always been my view. And I think some frequent defendants basically got used to having multiple opportunities to challenge a patent, and they got upset when that got curtailed even a little bit. And I think FinTIF, so I think that's why it was controversial. But fundamentally, I think it was sound policy. In every other area of law, two litigants fighting about something, we're only going to spend the judicial resources to resolve that dispute once, except the way the AIA has been implemented in the patent space will give, will provide multiple opportunities to resolve the same issue. And that's just a waste of society's resources and unstable and destabilizing to the patent system.
At least what Iancu said publicly was that the goal of the AIA was to provide an alternative resolution to the question of validity, and not to, like I said, extra bites at the apple for that.
Yeah, and it was supposed to be I think the phrase he used, and maybe it was somewhere in the history, but like a cheaper, faster alternative. Yeah. And I think everyone can get behind the idea of a cheaper, faster alternative in the abstract. Yeah. No one likes, paying lawyers except maybe lawyers. So yeah, in the abstract, if it was actually an alternative, and it was actually cheaper and faster, that would probably be an improvement. But I think in way too many cases, the actual effect of the IAA has been to increase patent litigation costs and drag out patent litigation.
You said Iancu supported a balanced system. When the USPTO, while you were there discussing those changes, did the fact the one of the problems that you're trying to solve is the PTAB invalidating too many patents. Like you said in the abstract, all right, if it's a true, fair alternative, it's cheaper and faster, if it's good, but obviously the results that it was reaching were different, statistically at least. Was that an issue, a problem that you're trying to address?
Not specifically the number of patents that were being invalidated, and I don't know that is necessarily a problem one way or the other if the process is fair. I think part of the issue is also, which is a slightly different issue with PTAB proceedings, is the burden of proof. And I think that might actually explain a good portion of some of the statistics that folks cite about the invalidation rate, is that when you're in district court, you're under the clear and convincing evidence standard, and when you're at the PTAB, you're not. The bill from Senators Coons and Tillis actually puts the PTAB under the clear and convincing evidence standard.
And do you think that will have an impact in isolation?
In isolation, I certainly hope it would. Okay. I mean, if the PTAB judges are applying the statute honestly, then like fewer cases would reach the threshold of clear and convincing evidence than preponderance of the evidence. So I think it actually would change. Now, that bill hasn't passed. Who knows if it's going to pass? I doubt it would pass this session of Congress, just sort of where we are in the political cycle. But I was pleased to see it had lots of support from a variety of different camps. And I think today, a couple of members of the House introduced a companion parallel piece.
All the changes that we were discussing regarding to the PTAB, they were finally submitted as proposed rules to the OBM in September of 2020. Why did it take so long?
It takes writing rules, even under the best of circumstances, is a pretty time-consuming process. You got to think. I mean, you're writing effectively a statute. You got to think carefully about every single word. In addition to, at the same time, hashing out what the policy should be, probably among people that disagree or that don't necessarily agree about exactly what the policy is, and certainly not every jot and tittle of what the policy should be. So it's a time-intensive, labor-intensive process. As far as why it didn't ultimately get through.
Well, actually, before we get that, so were you guys getting pushback from the White House, or was it the last thing they wanted to think about is some USPTO PTAB rules? Was it kind of not a...
Well, I'll say this: when by the time you get to October 2020, that was a month out from the election, and at that point there was just the proposed rule. So there was once it became clear that President Trump had not been reelected, it was pretty clear that Director Iancu wasn't going to be there, and there was certainly no way to get a proposed rule put out there, get the comments, and get a rule finalized.
We talked about definitive factors, and there was actually some hope. I was talking to some people who worked at the PTO at the end of last administration, and they were optimistic that maybe the Biden administration would pick up where they left off, and that didn't happen. What was your perspective? Where did you think things would go?
Where things went is about where I expected. I did have some hope that things would that the Biden administration would take a different tack than the Obama administration did. And I think it's maybe marginally more favorable to IP holders than the Obama administration was. But I'm not entirely surprised. But there are Democrats, Senator Coons, who, obviously want to, implement some reforms to the AIA.
Yeah. And I think it's interesting to look at the discretion denial statistics. After those changes were made at the USPTO, it actually statistically, I don't think it increased that much, but discretionary denials went up from about 10% to 20% on procedural grounds. So applying definitive factors, for example. So most 80% were still not denied on procedural grounds. As soon as there happened a change in the administration, even before there was a new USPTO director, it dropped by 50%. and I'm like, how does that happen? Were people at the USPTO, they're just waiting, waiting for a change of administration so they could go back to doing things the way they were done, or was the Biden administration just so efficient, saying, on day one they implemented?
I think changes in administration matter, and it's sort of the way that has played out under Director Vidal. I'm not surprised. She kept FinTIV, but has made other changes to it that have made FinTIV much less of a factor in PTAB litigation.
Yeah, and obviously when Director Vidal came in and she rolled that back. So she came in April of 2022. She rolled them back in June of 2022, which is for government, like you said, things happen. They're complicated, record time, and as soon as she rolls them back, basically the denials based on the FinTIV factors drops down to practically zero. I think there's maybe one or two cases a quarter. I'm surprised by that. If I'm a PTAB judge and they change the factor somewhat, but I can still come to a similar decision by applying these different factors. I mean, what is happening? Is it like a wink, like kind of the PTAB judges know what they're expected to do and they do it? Or like these, if you look at these statistics, it's kind of crazy, right? That it goes from 6D denials a quarter to kind of 1 a quarter.
Well, I don't, I couldn't account for what's going on in each individual PTAB judge's, judge's mind. I'd, take what they write at face value. But I do think, I think it's basically a shame that, because I think FinTIV was fundamentally good policy, and I think it also gets a bad rap. Like I've ended up talking to a number of reporters about PTAB policy, and in particular the VLSI situation, the VLSI v Intel case, or with Open Sky, and I mention in all of them that Intel already got 2 bites at the apple. They brought their original PTAB proceedings, and then they also got to challenge the validity in district court. And all of the reporters always say to me, well, but like they didn't really get a chance at the PTAB because it was denied under FinTIV. And but the merits have always been a part of the FinTIV analysis. And so like they did get 2 bites at the apple, and I think the FinTIV case was a good way to cut back on duplicative litigation.
What happened to USPTO in terms of the FinTIV rules and so forth didn't surprise you much. What about these the advanced ANPRM rules on the PTAB? To me, at least, when I look at them, if you look at the collection of them, it's kind of a concession, at least on some level, that maybe the PTAB is not operating the way it should. That's why all of these different changes should be considered. Did that surprise you? Did that Director Vidal kind of came to that conclusion at this point?
No, and I wouldn't, and I think I would probably quarrel with the suggestion that she came to any conclusion at all necessarily as a result of the ANPRM. When I read it, what struck me was that there were a lot of proposals pointing in 2 different directions. Some more favorable to, some to make things easier on petitioners, some to make things easier on patent owners, So I think what she was trying to do was put out for potential comment the universe of proposals that people interested in the PTAB would potentially advocate for, without necessarily taking a position on what she thought or what the agency thought the ultimate result should be. Now, a lot of the proposals in there I thought were great. Some of them I thought were okay, and some of them I thought were not good at all. But I don't think that's. I think that's a function of her, with the ANPRM, trying to cover a large universe of what's potentially potential changes you could make.
So, I mean, at the point she put them out, she was already getting criticism for asking for too many requests for comments. and she puts out these collection of rules. What do you think drove her to do that she decided to put that out there?
I don't know. I will say I think it was a mistake. And it's, the USPTO has done this before where they put out an ANPRM or a request for comments rather than just going to a proposed rule when they already have in mind what they might want to do. And it's much more common for other agencies, and I think the USPTO should have just put out, okay, this is what we think the answer is, and you get comments and you can change based on that. And maybe you put in occasionally option A or option B in your request for proposal, but that allows you to actually move more expeditiously to an actual final rule.
And you mentioned you thought some of the proposals were good, some were bad, some in the middle. Any ones that stick out to you either way on the good or bad side?
Yeah, I mean, on the good side, I think the proposal regarding standing, and I use scare quotes there because it's not exactly standing. I thought that was in general pretty good. There are changes I might make to it or tweaks I might make to it, but making it harder for frequent petitioners to use proxies to bring their petitions so that they can, perfect their own petitions or get two bites at the apple. I think that that is a good thing because those kinds of challenges are unfair and destabilizing. On the bad side, and I think this goes to back what I was saying, there's sometimes petitions proposals pointing in two opposite directions. You had a proposal to basically allow petitioners to pay money to get more words or effectively file a second petition, which I think it is not very good. Sometimes, extra word counts in briefs are justified, but that justification should be on the merits, not based on, how much money the party is able to pay.
For the latter question, there's a controversy because people say, some of these PTAB rules are pretty arbitrary. So it allows patent owners to come up with clever strategies, file claims that makes anybody challenging those patents, makes it much more difficult to challenge. An example is obviously, for example, using means plus function claims. Do you think there's any truth to that some of those page limits and so forth are kind of arbitrary? And
I mean, they are arbitrary, but you have to have an arbitrary rule. You can't just say you get to write as much as you want in your petition. I mean, courts have rules, but by the same token, if there's a particularly complicated case in court, then you can ask the judge, I think this deserves more page limits because of how complicated it is, and the judge, if you're right, will grant that to you. If someone has a patent with 500 claims in it, and someone's being accused of infringing all 500 claims, that probably deserves a greater page limit. My point is not so much what the page limit should be, whether it should be 10 pages, 20 pages, 1,000 pages, but how do we decide what the page limit should be? And it shouldn't be based on how much money you can pay.
And you mentioned you compared to how the courts work, which is, that's another thing. When the AIA, when it was first envisioned, people thought it would be more like a judicial proceeding, right? People thought maybe you'd even have witnesses, oral hearings, and so forth. Now it's really more of an exchange of papers. Do you think that's an issue? I'm asking you because you obviously have a kind of a broader perspective on law and other areas of practice.
Yeah, my own view is that I wish the whole proceedings occurred in Article 3, and that's not just in the patent space. I think it's generally better for the reality and perception of fairness to have the Article 3 protections, and that agencies should have to make their cases, or disputes between private parties should be brought in front of Article 3 judges, because there are good and important protections written into the Constitution for those. So when Congress creates administrative tribunals, they can do that, but I generally think the country's better served by having Article 3 judges, even generalist Article 3 judges, decide those kinds of disputes.
So going back to the NPRM rules, there's one of arguments being made with people who are unhappy because some of these rules is that they're inconsistent with the AIA. The administration can't just make up rules like that. But you hear that about any administration rules that somebody doesn't like. They're inconsistent with legislation. And obviously, you see things that are rules that are way less connected to the original legislation. Any thoughts about that subject, about what is the discretion that the USPTO director has?
Oh, I think she has a huge amount of discretion. I'm not sure that that's necessarily a good thing from a policy standpoint, but the way the statute's written, I think she has a tremendous amount of discretion. Do any of the rules or proposals in the ANPRM go beyond that? I don't know. It probably depends, and part of the reason I don't know is that we don't actually have any rule text. But I think in general, there are very few limits on her institution power and even how the proceedings go. And that was by design from Congress's point of view.
I don't know if you'd agree, but it's maybe a bit too narrow-minded if you just focus on AIA and the patent world to say, the judges would, of course, not allow the administration to institute rules like that based on
I don't know if any challenges to those would be successful. I tend to doubt it, but it probably depends upon it. Well, it certainly depends upon what the particulars are of each rule.
So the public comment period for these NPRM rules are closed. What do you think will happen next?
That's a good question. I think it's possible we'll see some actual rules come out of it, or proposals come out of it. I think they'll probably be much narrower in scope than what we saw in the ANPRM. And I also think that whether or not we actually see any final rules probably depends upon the outcome of the 2024 election, because if a Republican is elected president, then probably Director Vidal won't be sticking around, and it's probably going to be after 2024 that anything would ultimately get finalized.
So probably not enough time.
No, I don't think so, because they're probably going to need 3, 4, 6 months to come up with a proposed rule. Yeah. That's going to have to go through OMB, go through comment again. Then they're going to have to get all those comments. Then they're going to have to write the actual final rule and write all of that up and submit that to OMB and then finalize it. And, that's probably, you're looking at, by the time all that happens, around the election time.
So what advice would you give to the next USPTO director who wants to implement a change that will stick, short of getting legislation passed? What can they do to make that happen?
Well, I think in general, actually, legislation would be the best. And if you can work with Congress to get some of that stuff to get improvements written into the law, that would be the optimal situation. But as far as stuff that is and properly should be within the director's discretion, I think rules are the best way to go. You get the benefit of public comment. You get some stability in the system. There's a place for guidance documents or adjudicate, making things precedential. But I think on the whole, the public is better served across the government when things are done through rulemaking.
What is the advice in terms of successfully going through a rules process early on?
It's a time-consuming process, so start early. And I saw this. My experience with this is more from my perspective at OMB than PTO. But you've got to start early because it's just a time-consuming process, and I think probably less likely at PTO than other agencies. But lots of agencies just assumed that they were going to get sued the day that the rules went final. final. And, pretty often that was the case.
Start writing the rules the day you get nominated? Or?
that might be a little too early, but I think if you have, if you know what you want to accomplish, you probably want to start working with your colleagues at Commerce and OMB and the White House early, and try and get a solid rule package together sooner rather than later.
Now you're back in private practice, like you mentioned. Is there anything, I guess, that you've spent time in government, have a different perspective on being back in the private sector about patent system, or you might have not thought about while you were in government?
I definitely understand how government works better, what motivates agencies, and why agencies do some of the things that they do. And I enjoy sharing that with clients and sort of helping them understand and navigate, what is an ANPRM and what's the difference between that and an NPRM. Like most people don't know and, are probably lead perfectly happy lives without ever finding out. But, getting to share that with them when it matters.
What about the flip side of that? Is there anything that you're hearing about what clients are going through you didn't think about while you were in government?
Yeah, actually, I think a lot of the details in how litigation matters, or a lot of the details in rules in the patent system, matter a huge amount. Even things that seem not terribly important on their face, and maybe not have seemed important to me when I was in government. I don't know. I wouldn't have thought about it, I don't know. But the page limit thing that I mentioned, right? That matters a lot, because now a defendant, if a petitioner can double their page limit, that means that the patent owner now has to pay lawyers, twice as much to deal with it, and that increases the cost of patent litigation, right? So even little things like that you don't necessarily think that seem like not a big deal, I understand why people fight about them, because they actually can drive outcomes.
I guess it's a way to increase the patent owner's cost.
Exactly.
Okay.
Yeah.
That's interesting. So you mentioned, you help companies kind of enforce their portfolios and so forth. Any advice about building a strong portfolio, a patent portfolio that hopefully an attorney like you can enforce one day?
It's important that the patents be valid. My experience isn't so much on the prosecution side. I'll say I have some clients that they don't necessarily keep prosecution open, and that can be hugely helpful. And
a recurring piece of advice.
Which I know as a prosecutor, you probably tell all your clients, so you should always keep prosecution open.
It's costs as well.
I understand why. I understand why they don't. But when someone comes to me with a patent and says we'd like to enforce it, if prosecution's open, that's a huge upcheck. I don't think I have a ton that's not stuff that people wouldn't ordinarily think. If you have more patents is often better, but you do want to focus on the most valuable ones. And open prosecution, I mean, the standard things you'd think of, as a prosecutor.
No, that's all good advice. I mean, another thing you haven't, an understatement is you haven't abandoned the policy world. You're still interested in a lot of patent policy issues while you practice. Is there any advice that you would give to patent owners or anybody else, I guess, in the patent system about how they should think about influencing what the government is doing, the rules, the Congress, or should they kind of just leave it to others? I don't know.
No, well, I actually think the most important thing is that they should think about it. Yeah. One thing I noticed, and I don't know if you noticed it, because your office is in Virginia, but for a long time out in front of our office here, there was a billboard on the bus stop that said "Patents kill."
Yeah.
I think I may have posted about this at one point. I know if the Scott McEwen has as well. But when I first saw that, I thought oh my gosh, like I handle these things every day. I had no idea they were so dangerous. But I mean, like, of course, the whole thing's about drug pricing.
Yeah.
I
think that was the vaccine, right? The whole, they were pushing for a COVID vaccine.
It was, I think that, but also like more generally drug pricing. But like, I think there's way more policy push and marketing savvy on the part of the folks that want to weaken patent rights than on the opposite side. And I think for companies that depend on their patents and IP rights for their business, I think lawmakers and policymakers need to hear a lot more from them and the public generally. The idea of the patent troll narrative, has a lot of believers. I think because a lot of marketing and lobbying money was put behind it.
All right, great point to add on. Thank you so much for doing this.
Thanks.
Thank you for listening to Clause 8, the voice of IP. If you enjoyed this episode, please share it with others and leave a 5-star rating in your favorite podcatcher. We'd also like to thank Harity & Harity LLP for their generous support. For more information, visit voiceofip.com. And don't forget to check out our full archive of past episodes. Clause 8 is a brouhaha audio production. Thanks for listening, and we'll see you next time.